Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. Today I want to discuss just two things that are updates from USCIS and U.S. immigration laws. So a couple of weeks ago, I made a video about how immigration was scheduling their appointments. And in the past, the government used to give about 30 to 33 days notice whenever they schedule in-person appointments. However, that changed a couple of weeks ago when they started sending out these interview notices and only giving individuals about 1 to 5 day notices. And this was a very, very big deal because if you are applying for adjustment of status or a green card and you did not submit a medical exam with your application, you were required before the interview to submit and furnish that medical exam. Most medical exams take about 7 or 10 days to complete. So if you received the notice and you only received a 5 days heads up, most likely you weren't able to get that medical exam on time. Additionally, if you are applying for citizenship, there's a study requirement that you have to memorize 100 questions. And if you didn't have a long or a good amount of time to prepare, most likely you are going to fail that naturalization test. So what I think happened is that immigration received a lot of complaints, and you can bet that they received a lot of complaints from our office as well. And we told them 1 to 5 days is not enough time to prepare a client, and especially to block out time in our schedule to go with the client to the interviews if the need arises. And now immigration has reverted back to their old calendar system, and they are allowing a decent amount of time, about 30 days or so, when scheduling an appointment for the actual appointment date. So this is very good news on our part. The second bit of good news that I want to give you today is that immigration has made a new policy change regarding premium processing service. So premium processing service is an option that some cases are allowed to file a premium processing form, which is the I-907, pay a filing fee of $17.50, and then their case can be decided within 10 business days, which is very good. And usually these applications are mainly for people that are applying for work petitions. However, starting on June 13, a couple days ago, the government is now allowing people that are applying for I-539 applications to submit a premium processing application. So let me tell you why this change is so important and so valuable. So in the past, if you were a foreign national and you entered the United States on a visitor visa, or let's say a J1 cultural exchange visa, and then after you came to the US, you were given an authorized period of stay for 6 months. During those 6 months, you decide that, hey, I want to stay in the US longer, and I want to pursue studies in the US as an F1 student. So then in this situation, you have two options. One, you can leave the country, go back to your country and apply for an F1 student visa, or you can stay in the US and apply for the I-539 application to change or extend your non-immigrant classification to an F1 student. The big problem with this is that usually when people come as a visitor, they're only given up to 6 months to stay in the US. So during these 6 months, they have to apply for the I-539, and then they have to wait for a decision. And many times the I-539s take a very long time to process. So now with this new change, individuals don't have to wait so long. So if you already have an I-539 application that's currently in progress or pending with immigration, good news. Starting on June 13, a couple of days ago, you were able to file for premium processing service. That means that you can upgrade your case by sending the I-907 application form and fees to the appropriate place and notify them that you want to get it processed within 7 to 10 business days. And if you haven't filed your I-539 application yet and you're looking to file, good news. Starting on June 26th, the government will accept I-539 applications concurrently and at the same time at those premium processing requests. So if you haven't filed yet and you have only a few days of stay left in the US and you're thinking about pursuing a US education, good news. You can file your I-539 applications concurrently with a premium processing request. This means that you can receive a decision within 10 business days. Again, these are recent changes to U.S. immigration laws. Again, I'm attorney David Nguyen. This is Winning Law, and we hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.